Hello guys, this is Ishita, the legal intern at LEXCLIQ. Today I'm gonna brief you out about abatement to suicide. Suicide or self-annihilation is a common incident affecting a large number of people of all the classes throughout the globe. It is an exceptional crime where both the accused and victim is the same person affecting himself. This crime has been elaborated in the Indian Penal Code 1860 and provides for the punishment as well to control further commission of offences. Attempt to suicide and abatement of suicide are two different concepts which is punishable under section 309 and section 306 of IPC. Section 306 deals with the punishment for abatement of suicide, while Section 309 punishes for attempt to commit suicide. Abatement of attempt to commit suicide is outside the purview of Section 306 and it is punishable only under the Section 309 read with Section 107 IPC. Therefore, even where the punishment for attempt to commit suicide is not considered desirable, its abatement is made a penal offence in the interest of society. Such a provision is considered desirable to prevent the danger inherent in the absence of such a penal provision. Abatement in its literal sense means instigation of a person to do or not to do an act in a certain way or aid given by some person to another either on his own choice or circumstances arising out of joint and constructive liability. Abatement to society involves a mental process of investigating an individual or intentionally helping a person in taking his life on his own way. This section is based on a reasonable public policy to prevent other persons' involvement, instigation, and aiding in terminating one's life. It takes care of the situation and threats imposed by death baiters. Section 305 under IPC 1860 provide for the punishment of an individual who abets the commission of the suicide of a child not being 18 years of age, an insane or an idiot individual or a person being intoxicated, which is death or life imprisonment or imprisonment for a term not exceeding 10 years and shall also be liable to a fine. So there is a constitutional validity of section 306 IPC. In Naresh Moritaru versus Union of India, the validity of Section 306 was absorbed and the court held that Section 306 constitutes an offence which is independent in character entirely. It is structured on the principle of public policy that no individual should involve himself in or instigate or aid the commission of crime. It is in consonance with Articles 14 and 21 of the Indian Constitution and therefore inviolative. Abatement of suicide. For conviction under this section, the prosecution has to prove commission of suicide by the deceased, instigation done by the accused for committing suicide, and the mental state of the accused. When the suicide is committed, then only the liability arises for abatement. In case of an attempted suicide, provisions of section 306 will not be applicable. In accordance with the definition of abatement given in section 107 of IPC, the offence of abatement to suicide must be constituted. There must be instigation or engaging in conspiracy or assistance in the commission of offence. Now there is a various case laws analysis. I'm gonna tell you about one. Chitraj Kumar Chopra versus State Government of NCT of Delhi. In this case, the court analyzed the dictionary meaning of the word instigation and goading. The court opined that there should be intention to provoke, incite or encourage doing of an act by the latter. Each person's suicidal pattern is different from others and has his own idea about self-esteem and self-respect. Therefore, no straitjacket formula can be created and imparted in dealing with such cases, as each case has to be decided on the basis of its own facts and circumstances. Intention to commit suicide is essential in order to constitute an offence under this section, where an accused jumped into a well to avoid the police and later came out of the well on his own accord. It was held that in absence of evidence that he jumped into the well to commit suicide, he couldn't be convicted of an offence under this section, that is section 309. The constitutional validity of section 309 was initially struck down as a cruel, irrational provision violative of article 21 of the constitution in case of P. Rathiram versus Union of India. However, in Jan Kaur versus State of Punjab, P. Rathinam versus Union of India was reversed and the Constitutional Bench of Supreme Court upheld the constitutional validity of section 309 by indicating that it does not violate Article 14, 19 and 21 of the Indian Constitution. So there are various cases involved in this. Even international scenarios of law regarding abatement to suicide have occurred. Several countries and jurisdictions around the world like Bangladesh, Ghana, India, Kuwait, Nigeria, Pakistan, Singapore had its stringent laws regarding the offence of suicide, which can be attempted suicide also. In England and Wales, the Suicide Act of 1961 has abrogated the rule of law whereby it is crime for a person to commit suicide. Section 21 of the Act imputes criminal liability for the complicity in another's suicide and makes the abater liable for the imprisonment which is for a term for not exceeding 14 years. So, there are a lot of questions regarding it. People ask, what is the punishment provided in United Kingdom in relation to abatement to suicide? According to section 2(1) of the Suicide Act 1961, the abater who aids in any form to the person who wants to commit suicide is made liable for the offence and shall be convicted on indictment to imprisonment for a term not exceeding than 14 years. So that was all with my in knowledge. I'm gonna now conclude here. This is I hope you like the video. Please do like, share and subscribe the channel. Thank you.